The uMkhonto WeSizwe party's appeal against the Independent Electoral Commission has been successful, and that's after the IEC upheld an objection to remove former President Jacob Zuma from the party candidate list. Now, the IEC argued that Zuma's jail sentence barred him from entering the race, but Zuma's lawyers contended that the commission had also failed to take into consideration Zuma's remission of sentence. Legal expert Zola Majava has more.
The issues that engaged the attention of the Electoral Court were quite vexed issues, new issues that never got tested post our democratic dispensation. So overall, I think it is a win for participatory democracy and the rule of law. I think it was a difficult case for both parties, but the balance of scale seems to have been tilted in favor of Mr. Zuma and the MK party. It would be very interesting to read the actual judgment, because we are none the wiser now, because all that is in the public domain is the ruling. So how the judges or the court would have arrived at their decision would obviously, embellish the discussion that we are having. But to say it was an open shut case, I think it would be unfortunate. But on the whole, both legal parties did make what appeared to have been highly persuasive submissions. I think it probably turned on the non-appellability aspect of Rule 47(1)(e), because nobody could see that coming. And that is where I think the turning point might have been. And I'm saying this in deference to the judge's reasoning. I think they probably bit more than what they could chew. It was not their place in the first place to make that determination. I seem to be with Advocate Mpofu on this one. That is a call to be made by the National Assembly once they have been constituted. It may well be that the National Assembly could have taken the view similar to the view that they themselves expressed, but they seem to have acted outside of their scope, let alone whether or not they interpreted that particular section correctly.